Good afternoon. Good afternoon, and welcome to Redistricting in 2011. It's a panel featuring some of the top voting rights litigators and thinkers in the country. But before we begin, some brief reminders and announcements. I'd like to remind you to please turn off your cell phones or put them on silent because this session is being taped. I also need to announce that we have allotted 45 minutes of networking time at the end of this session for attendees to engage with panelists and other convention participants. We'd also like to thank Jenner and Block for sponsoring this panel. We will have a question and answer period at the end of presentations and questions amongst the panelists, and I'd like to remind you, and will remind you when we start the Q&A, to please use the microphone and to phrase your questions in the form of a question, okay? All right, thank you. Also, immediately following the session, there will be remarks by Congresswoman Donna Edwards at 5 p.m. in the presidential ballroom. And the day will conclude with a reception in the Congressional and Senate rooms at 6 p.m. And volunteers will be on site to help direct you to these locations. I am Gilda Daniels. I'm an associate professor at the University of Baltimore Law School, and I'm your moderator for today's program, and where we will talk about some very interesting and intriguing issues, and hopefully we'll be engaging with all of you as well. After each decennial census, jurisdictions are mandated to redistrict, and in the 2000 census, the nation's population increased by 10%. California remains the most populous state, while Wyoming has the fewest residents, and during the last decade, Texas gained the most numerical residents, with an increase of over 4 million residents, and Nevada's population increased nearly 35%. Now, the importance of these numbers is enormous. The census count determines funding for transportation, utilities, education, health services, and many more important expenses vital to life in this country. Another extremely important use of the census is determining the numbers for apportioning congressional seats, and the significant use in redistricting those seats, as well as state legislative and local governing bodies. Most states have begun the task of drawing legislative districts for the United States Congress and state legislatures. And this critical process is weighted with political and legal landmines. Now, the process of redistricting has become even more interesting and potentially challenging with recent Supreme Court cases and the results from the 2010 midterm elections. Now, from the congressional seat to water districts, considerations of politics and race are involved at every level. Some states have attempted to limit the influence of politics and incumbency through the use of commissions. Others have continued the process of legislative construction of districts. Now, today we hope to discuss these and other intriguing issues, beginning, of course, with the census and what the numbers say and its impact on the redistricting process, and then moving on to the legal landscape and what the impact of the Department of Justice, the effect of what's the DOJ effect on the redistricting process, and finally some predictions and some best practices recommendations. And all of this will be handled today by our panelists, our esteemed panelists today, and our panelists include Kristen Clarke, who is the co-director of the Political Participation Group at the NAACP Legal Defense Fund. She oversees and coordinates the activities of LDF's legal program in the areas of voting rights and election law. And in 2009, LDF successfully defended the Voting Rights Act against a constitutional challenge in the Namudno case, which is Northwest Austin Municipal Utility District number 1 versus Holder. She was also a staff attorney in the Department of Justice Civil Rights Division in both the voting sections and the criminal section. She writes frequently on issues concerning race, law, and democracy. In her latest book, and I think this is the latest one, Barack Obama and African American Empowerment, The Rise of Black America's Leadership, which was co-edited by the late Dr. Manning Marable. We also have Keith Gaddie, who's a professor of political science at the University of Oklahoma. He is the editor of the Social Science Quarterly and is a litigation consultant in voting rights and redistricting cases for both parties. He has also testified before the United States House and Senate. We have Gerald Hebert, the executive director and director of litigation for the Campaign Legal Center. He is a sole practitioner in Alexandria, Virginia, who specializes in election law and voting rights. He's a former DOJ acting chief and deputy chief of the Civil Rights Division voting section. He has taught election law and voting rights courses at Georgetown University, American University, and the University of Virginia. Next we have Marcia Johnson-Blanco, who's the co-director of the Voting Rights Project at the Lawyers Committee for Civil Rights under law. And she's the co-director of the Voting Rights Project and is responsible for election protection, election reform, redistricting, and felony disenfranchisement program areas. She leads the Lawyers Committee's efforts to reform election administration at the local, state, and national level. And Marcia has also litigated claims under Section 2 of the Voting Rights Act and against disenfranchising voter identification laws. She is also an adjunct professor at Georgetown University Law Center. Last but certainly not least is Nina Perales. She is the Southwest Regional Counsel for MALDEF. She directs MALDEF's litigation, advocacy, and public education efforts in the Southwest, and she specializes in vote dilution and redistricting cases, and she also successfully argued LULAC versus Perry in the United States Supreme Court. Now today, our format will be a little different. I'm going to ask our panelists questions, and we're going to spend probably the first 45 minutes to an hour with asking them questions, and again, we'll start with the census and then move to the legal landscape and what some of the practical impact is of census numbers and what the redistricting process is. And then we'll have an opportunity for you all to participate and ask our panelists questions as well. So we're going to actually start with where this all starts, I guess, with the census, and start with Kristen Clarke. And Kristen, I want to ask you if you could just explain to our audience what the census, what we found in the census, and that meaning what demographic changes did we see, where were increases, et cetera.
Certainly. I think the biggest takeaway from the 2010 census is that we're becoming an increasingly diverse nation. There have been some dramatic shifts that have happened over the course of the past decade. The Latino population, for example, has grown 43% over the last 10 years, moving from 12.5% of the nation's population to 16.3%. The Asian population as well increased by about 18%, moving from 3.6 to about 5% of our nation's population. And the black population remained just about constant, and it's now about 12.6%. Overall, the white population of the country has dropped from 69 to about 63.5%. And at this rate, this means in about 2020, we may see numbers that are about 58%, meaning persons of color may represent about 42% of our nation's population. So I think the biggest takeaway is that communities of color continue to expand, which I think creates some interesting questions, challenges, and complexities for redistricting. I think as many line drawers go back to take a look at maps and current configurations, they need to be prepared to now draw maps that look very different and that fairly reflect growing minority voting strength in various communities.
What about shifts in population from north to south? What are we seeing there?
Yeah, so two interesting cases, I think, are New Orleans and Detroit. In Detroit, both Congressman Conyers and Congressman Hanson Clarke lost 800,000 black voters from their districts combined. And in New Orleans' 2nd Congressional District, which encompasses New Orleans, they lost 120,000 black voters. So in the state of Louisiana, this actually created some very interesting challenges for both their congressional and state legislative redistricting. The congressional district that has now been proposed and is pending before the Justice Department stretches outside the boundaries of New Orleans for the very first time in recent memory, and now stretches all the way up to Baton Rouge. So it goes up the interstate, probably 70 or so miles, and captures black population in the southern end of Baton Rouge. So again, a very dramatically different looking map, a new district that now probably captures a lot of the black population that was displaced as a result of Hurricane Katrina and moved up north to Baton Rouge. But lots of dramatic shifts that have happened over the course of the past decade. Some of it attributable to hurricanes, some of it attributable to the foreclosure crisis,
Right, economics.
which has resulted in a great degree of transience in many communities, but lots of changes and shifts.
Right, and Nina, with those shifts, what do you see the impact on redistricting? What's the impact on redistricting?
Well, with respect to apportionment first, we saw seats, the 435 seats in the House of Representatives, which have to be apportioned by population, shifting out of what's referred to as the Rust Belt states and down into the South and the Sun Belt states. So we saw the big winner, my state of Texas, getting 4 additional congressional districts. It wasn't entirely due to Latino population growth. It's just a really growing state, but Latinos did comprise 65% of the growth in that state. California, Latinos were able to prevent California from losing any congressional seats. So California didn't gain or lose, but Latinos comprised 90% of the growth in that state. Anglos represented negative growth in California. So the Anglo population in California is numerically going down. I think that minority growth in general prevented certain states from losing more seats than they otherwise would have. So Illinois, which is near states that were losing a lot, only lost 1 seat. And this is no doubt the contributing effect is the growth in the minority population.
So, and one thing that we haven't discussed yet in regards to what the actual numbers show is what the impact of prisoner allocations would be. And so, Marcia, can you speak to that?
Yes, so part of the reforms in redistricting, which I know we're going to get into later, is to end what is called prison-based gerrymandering, where that is counting prisoners where they're imprisoned and not where their last known address was. And because of the unfortunate fact of criminal justice system where you have minorities disproportionately represented in the criminal justice system and prisons largely in rural areas away from urban centers, you find that this minority population is being counted in urban centers rather than in, rural areas rather than in the urban centers where they're from. So there's been states such as Maryland, New York, and Delaware and Colorado, which have passed laws to allow in the redistricting to count that population back at their last known address.
Okay, and there's some states, states like Maryland and New York.
Right.
How's that occurring now? I mean, what are we seeing what the impact of those changes are?
So what happens is that the census does a special calculation for those block groups that the states can then use to take the numbers, look back at the last known address, and redistribute that population. And so it's sort of has resulted in a rural-urban dispute. And for example, in New York, and in a case that LDF is involved in, I know, the legislatures are particularly unhappy about that, having that as an option and have filed suit, and actually have raised prison-based gerrymandering is also part of a partisan gerrymandering because of who they think that the voters would vote for. And so, and also comparing prisoners to other transient populations and why is there a distinction being made for them. So it's now being played out. We'll see how it is in Maryland when Maryland gets its redistricting up and going, what kind of backlash there will be there, but that's the state of play at the moment.
Are we finding any questions about the reliability of these numbers, either for minorities or prison counts?
Well, I do know that there is there are questions about how well the numbers will be allocated back. The census just gives the raw numbers. There has to be a mechanism to attach the particular individuals back to their home districts, and that depends on the procedures in the state, and that has caused some concern, but we'll see how the states put that process into place.
Okay. Kristen, you wanted to add something?
Not on the reliability point, but I just wanted to kind of help put a face to the problem. So African Americans make up about 12.7% of the general population in the nation, but are 41.3% of the population of federal and state penitentiaries. So this has very significant and stark consequences on African Americans. And so let's talk about a state and what this actually means in reality. In New York, 66% of all prisoners in the state of New York come from New York City, but 91% of them are incarcerated in rural upstate New York. So because of the steps that New York has taken to correct this problem, we actually are, able in this one place to, we're overcoming a grave threat to democracy. New York, Maryland, Rhode Island have all taken steps to correct this enormous problem. California will hear some testimony on this issue. There's a hearing scheduled next week. Connecticut, we made some progress but hit a roadblock, but it's actually a huge issue that we're very glad, we've gotten some movement in some states this cycle on.
Right. Certainly a very huge issue in regards to what the numbers indicate, and as you said, putting a face on these numbers. And as we talk about, we'll certainly talk about race today, but and we want to also talk about what's the partisan impact of these numbers also. And we've certainly had during the 2010 election an increase in Republican governors as well as state legislators or state houses. So what are we finding is the impact of those changes as well on the redistricting process? Jerry?
Well, it's very hard to be optimistic when you look at the map, which I'll hold up just so you can see it.
No PowerPoints.
The red area states are controlled by Republican legislatures, and the governors don't look much better if you're a lawyer for blue states, which I am. So, as my friend Tom Huffeler of the RNC often says, if you don't think it matters who draws the districts, then let me draw them. When the numbers came out and the election results came out last year, it was widely assumed that, and you look at Texas, for example, gaining 4 new seats, and of course it's a state colored red on this map, and got much more decidedly so in the legislature, which went to a supermajority for Republicans. Yet, as Nina points out, a large part of the reason Texas is gaining 4 new seats is because of the huge, incredible growth of Latino population and African American population as well in that state. And so a lot of people, when they saw Texas gaining 4 new seats, immediately said, oh good, well there's going to be 4 new Republican seats coming out of Texas. But I don't think you can really do that and get away with it under the Voting Rights Act. So at least I'm counting on that. So, I think we'll see as a result, and we'll get to this later, you'll see states like Texas, when they draw their map, which they've done, probably file a declaratory judgment action in the DC court rather than go to what they call the Obama Justice Department, which is for the first time in Democratic hands during a redistricting, a post-decennial redistricting cycle. And we've seen other states do that, and I'll talk about that in a little bit. So it's not automatic that just because states that are so-called red are gaining congressional seats, that those seats will go to Republicans, but they certainly, it's a lot easier to defend a map once you've drawn it, because there are so few legal arrows in the quiver to really shoot a plan down that it's much better to be drawing a map than challenging a map.
Keith, did you want to add anything?
Well, yeah, Jerry has laid a very good foundation here, which I completely agree with. Jerry, you won't hear me say that again very often, but
I'm glad this is being taped.
very good. But there is some context here, which is all the Republican advantage that exists out there is mainly in the realm of solidifying gains or defending against overperformance rather than being about making additional gains. If we look in Texas, 2 of the seats that are held by Republicans in Congress right now are Section 5 covered districts down in the South Valley. I'm not entirely confident they can hold on to those in the long run, especially if Texas does the right thing and puts an additional district down there. In the state of Florida, Republicans already control 4/5 of the seats in the U.S. House. State of Georgia, Republicans control nearly 3/4 of the seats in Congress from that state. These are 3 mega states that have a total of about 70 seats, over 70 seats. There's not a lot of room for Republicans to put gains on top of this in these states, mainly because of the constraints of the Voting Rights Act. At best, what they can do is defend and maybe put in marginal gains, all things held equal. But, the realignment of the South has really taken hold and shows in this redistricting cycle. Here's a little fact to sink your teeth into. If you were to drive from Charlotte, North Carolina, back and forth all over the Deep South, into the panhandle of Florida, and make your way to Houston, Texas, you would find one white Democratic congressman. There used to be about 50 from down there. There's one. They ought to put him under glass so that in future generations they can see what one looked like, because the breed is gone. There are opportunities actually for Democrats, depending how things could have played out. If Alex Sink had been elected governor of Florida, this would have created a powerful hand to have played in the Florida redistricting, especially with the passage of Amendments 5 and 6. So we have a circumstance in a lot of these Republican states where at best they can bolster their existing opportunities or their existing gains because they overperformed. As a friend of mine in Illinois put it, we won 6 of 5 targeted districts. So we have a peculiar circumstance where the Republicans outperformed even their greatest wishes. I don't know where they can stack a lot of additional gains, mainly because in order to do so, they have to do things that would probably violate the Voting Rights Act.
Right, so we'll certainly talk about the Voting Rights Act in a few minutes and its importance to this process. But before we get to that, I want Marcia to talk about legislation and what we're seeing in regards to reform legislation from these newly elected governors and state legislators.
Well, every redistricting period, at the end, there's an assessment of how well it went and how it can be improved upon. And after the 2000 round of the redistricting, the consensus among many, or some I should say, was that we need to get this out of the hands of the politicians. Not everyone agrees with that assessment, but there was, that's how it played out in California and in Florida, particularly. And in California, they went the independent redistricting route, where they now have a redistricting commission that has just released its maps, and we're seeing, reform in action. And I guess if, not many are pleased with what you're doing, what does that say about the process? And, I should back up and say a bit that with redistricting, I did a presentation recently, and I started talking about the law and populations and all that, and a politician came after me and he said, you know what redistricting is about? It's about power.
It is.
And, and that's what the reform gets to the heart of, I think, who has the power to decide what type of district you're going to live in, how that district is going to be drawn, what kind of input you have in the drawing of that district. So in California's case, the citizens passed the initiative to have the independent commission, and they have a 14-member commission now, which 5 Republicans, 5 Democrats, and 4 no affiliation. And the commission has been very active, having hearings, or failed to declare, I think is what it is in California. They've been having hearings, and they've just released their maps. And there is a big question of how attentive they have been to the input they've been getting. It's not just the process and singularly following, the standards, but, how are you listening? Are you responding? Are you reacting? And so that's the big question now, and they're going to be dealing with the reaction to those maps, and it's going to be very engaged, and we'll see at the end of that process how well it works out and what results from it. And I think, I don't have to be a soothsayer or anything to say this, but I foresee litigation.
Very clearly into your crystal ball. Yeah, I think
And
that's a good prediction.
and just quickly, with regards to Florida, rather than go the independent route, they decided to pass standards that the legislature has to follow, and this was particularly popular in Florida with Amendments 5 and 6, where 62% of Floridians voted for the amendments. And the new governor first withdrew the submission from DOJ for preclearance, and then finally submitted it again and had it recently pre-cleared. So we are now going to see in Florida how the experimented reform works, where you create standards that the legislature has to follow, where the legislature is hostile to those standards. and how do you engage in that process. So that is being played out, but I think it's what the reforms get at is the struggle with every redistricting is where the power lies and who gets to decide.
Right, who wins and who loses. The drawing of these
Exactly.
lines certainly can determine who wins and who loses. So it's about power. And you're seeing litigation. You're seeing 2020.
Yeah.
And so you're seeing litigation. I guess it's a good time to talk about the legal landscape now that we've talked about, what the numbers are and where and who's actually getting to draw the lines. So when we're looking at the legal landscape, we certainly have to talk about the Voting Rights Act and its importance to this process. And we know that we've had some recent Supreme Court decisions in the Bartlett case and in the Mudno case, and their impact could certainly serve as cautionary tales for Voting Rights Act enforcement. So I want to start with asking Nina, what is she finding in regards to Voting Rights Act enforcement, and how is Voting Rights Act enforcement factoring into this redistricting process?
Well, so far in the process, and I should probably contextualize this by saying that MALDEF has a nationwide redistricting project which covers 12 states of focus for our organization. And so we've been organizing and mapping and doing advocacy, informing legislators, and then also today we filed the first of what is expected to be a number of lawsuits. Today we filed against Texas. So what we're finding as we go around from state to state and we look at this issue from the perspective of Latinos, that some of the Supreme Court cases that have happened over the decade have a very practical impact on what we're doing and what other minority advocacy organizations are doing. So the most important case probably is the one called Bartlett versus Strickland, which said that when you're going to propose a district that is majority minority, it has to be majority minority. It has to be over 50% of the relevant minority population that you are proposing. Certainly there are many situations where minority voters can carry the day in the district at less than 50% because polarized voting is not complete, right? It's not 100, except in Texas. Sometimes, but there's plenty of situations where you have some crossover voting by either by either Anglos or some coalition voting by other minority groups. So it is possible to draw a district where minorities can carry the day at less than 50%. But the court has now announced that if you're going to go to court and you're going to say that a district has to be drawn, that you should meet the 50% threshold. 50% of what varies by circuit. So in most of the circuits that we work in, it's 50% citizen voting age population. So if we're going to propose a Latino district in Texas or in California, it's going to have to be 50% or more Hispanic citizen voting age population, and that's what Bartlett taught us. And I think there was a little bit of hearing that coming in the Lulac v. Perry case when there was an effort to defend a district from being dismantled that was not over 50% African American, but the argument was that it was in fact an African American opportunity district because of voting behavior in the primary and in the general. Paul, I didn't make you mad, did I? Oh, good, he's not here. I'm trying to say that as neutrally, did I say that as neutrally
It was pretty
as
neutral.
possible? Neutrally as possible. So I would say that Bartlett is looming over everybody who's doing maps and thinking about doing affirmative litigation to enforce Section 2 of the Voting Rights Act. And then probably the one upside from Lulac versus Perry is that yes, it's still possible to win a Section 2 case in the Supreme Court. It hasn't been undone. But I think we're seeing a slow tightening here and there of what some of the standards are for your prima facie case.
Okay. Kristen, did you want to add to that?
Yeah, so Nina talked about the Section 2 vote dilution provision, and I'll maybe comment for a moment about the Section 5 preclearance provision of the Voting Rights Act. This is a provision that many of us regard to be the heart of the Voting Rights Act. It's a provision that essentially requires 16 states, many of them deep South states, Louisiana, Mississippi, Alabama, the Carolinas, Georgia, Texas, parts of Florida, and several others, that they submit any voting change, including redistricting maps, for federal review before they can be put in place. Louisiana and Virginia have finished their maps. They're among the covered jurisdictions that now have maps pending before DOJ. DOJ looks in its federal review of these maps to see if the maps put minority voters in a worse position. Do they eliminate minority districts that were once there? Do they make reductions in the minority population percentages that would strip away the minority community's opportunity to elect? Do they pack voters? These are the kinds of questions that DOJ endeavors to ask when they conduct their Section 5 review. But jurisdictions can also go to the DC District Court for review, something we don't see often just because DOJ's process is quick, speedy, cheap. They have to make a final preclearance determination 60 days after reviewing a map. But there are many covered jurisdictions that have been emboldened and feel it necessary to bypass, as Jerry calls it, the Obama Justice Department and go straight to the courts for review. So this is proving to be an intensely busy cycle for the advocates and the lawyers who do this work. That said, Section 5 is also under attack. There was a constitutional challenge to Section 5 that was filed in 2006 and heard by the Supreme Court in 2009. Gilda mentioned that case at the outset. And the court, in this case, avoided the constitutional question that was presented to it and resolved the case essentially on statutory grounds. And the successor cases have now been filed. There's one case that's been filed by Shelby County, Alabama, that's now pending in the DC District Court. Another case that was brought by individual plaintiffs in North Carolina, another case called LaRoque v. Holder. And we understand that there are a few jurisdictions out there that may present their maps and also fold in alternative constitutional claims that they'll ask the court to turn to if for some reason the court finds the maps objectionable. So I think the fact that many of these pending challenges are out there certainly kind of creates a somewhat tense environment, this redistricting cycle. But what I find most notable is kind of looking at the trajectory of how Section 5 operates. And the reality is Section 5 has literally blocked hundreds of discriminatory voting changes in maps throughout the decades that it's been in place. And you see the spike, you see the greatest number of objections interposed at the outset of the decade, during the first few years of the decade. Literally, you see a spike kind of in the first, second, and third years that starts to taper off as you move through the decade. It's redistricting that kind of represents the moment where discrimination tends to really rear its ugly head when it comes to voting, and where Section 5 has proven tremendously effective in blocking a great deal of discrimination. Section 5 is good law today, and we most certainly, Nina and I and other organizations, stand by enforcing Section 5 and seeing that it does the work it needs to do to block discriminatory redistricting maps this cycle.
Right. So the challenge to the Constitution of Section 5 is real.
Yes, it's real.
Real, and certainly one that we all need to be aware of, and as you said, for those of us who understand the importance of Section 5 and the Voting Rights Act, to be vigilant and ready to defend it.
That's right.
And Kristen didn't mention that she was one of the attorneys at the Supreme Court arguing for the constitutionality of Section 5, and then the Mudno case also.
My colleague Debo Adegbile argued that.
He did the
case.
actual arguing. You were sitting at the
Equal job.
table. I
Yes.
saw you. She was and so Section 5 and Section 5 and Section 2 are, as I said, it could, and the way the Supreme Court is interpreting those provisions of the Voting Rights Act are somewhat under attack. But again, I think advocates are certainly arguing that the Voting Rights Act is still strong and certainly still the law, and in regards to how we should approach the redistricting process and what considerations jurisdictions should take in regards to how they draw districts is something that should be at the forefront of most jurisdictions. For example, I think in California, in their statute, they say that the Voting Rights Act is certainly one of the paramount considerations in actually drawing the districts, and how we can sustain or I don't know if we can talk about gains for for minority districts.
Oh, yes, we
here.
can.
We can. Good. Good. So tell me about the impact of enforcing Section 2 and Section 5 and how and gains or certainly maintaining districts. We've talked about Bartlett and how it's somewhat of a cautionary tale, and that it has to be a majority-minority district in order for the Supreme Court to say that the Voting Rights Act requires it. So what do you see in regards to gains? I know I'm getting a bit ahead of myself in regards to
Oh,
predictions.
you want to
but
skip to gains?
Just for a minute.
Well, it's not going so well right now, but it will. We'll get there. Certainly in the states where we're working, and I'll give you the example of California and Texas, which are a little bit ahead of some of the other states, not all of them, but for Latinos, there are 2 states that are important to us. We are drawing 3 additional congressional districts in California that are Latino opportunity districts, and that's our proposal. Right now, the commission, and I'll get to that, hasn't quite been seeing it the same way. In Texas, we don't have a congressional plan yet, but our proposal is for a +2 Latino Section 2 districts, so we are looking at gains.
Okay, good. And we talked more about the thing in other places. For example, in Louisiana, who lost a district, now they have 6 congressional districts, but African Americans are minorities and are about 30+% of the population. So they're, why aren't we talking about taking 2 of those 6 as opposed to hoping to hold on to 1? But certainly all issues. So that's why it's so much fun being a voting rights attorney and advocate and professor and everything else. It's a lot of fun. Let's talk about the lower courts and what's happening there. So Jerry, can you tell us what's happening with regards to Voting Rights Act cases on the lower courts?
Well, it's much more fun to talk about the lower courts than it is to talk about the Supreme Court of the United States. The only area probably worse off than the voting rights field is campaign finance law in the Supreme Court, so it makes me long for retention elections, frankly. But let me talk a little bit about some of the cases that are pending. We have a number of interesting cases going on, and for those of you who don't litigate in this area, there is always what I would call a rush to the courthouse because you want to be the first case filed challenging a map, because that will be the court that ultimately will render the decision with the first ripe case that has been filed. And so determining ripeness is often something that you actually have to vary from state to state, so you have to research that a little bit. But what we see is a lot of lawsuits, and there have been 30 lawsuits filed so far this year regarding redistricting plans or efforts. Texas leads the way with 8, I believe. That includes yours filed today. I had 7, but it's now 8. And a lot of those were lawsuits challenging the existing map on the grounds that the existing map violates the one-person, one-vote rule, that the Texas is either going to deadlock in the legislature or they're going to not have a map in time, and so you ask the court to draw a map. If the legislature then does draw a map after you file, well, then you want to challenge that map, you amend your complaint and challenge that. You also have, of course, in states like Texas, the opportunity to go to the Justice Department and advocate to the Justice Department or the D.C. court for why the plan should not be approved. As Kristen said, 2 states thus far have simultaneously gone to the Justice Department and to the D.C. court for preclearance of their plans. Ostensibly, the public statements of Virginia and Louisiana that did this said they wanted to avoid the Obama Justice Department, but apparently they forgot to read the statute, which says that the statutory defendant, when you sue in the D.C. court, is it doesn't say Obama Justice Department, but it does say the Attorney General, so Eric Holder is the defendant. So now, why are they doing that? I think they're doing it for 2 reasons. One is that if they submit simultaneously, the Justice Department gets to make a determination administratively under Section 5, they can, and if they preclear the map, maybe they feel, the states do, that with a federal D.C. 3-judge court overlooking their shoulder, they may play it more strictly according to the law than they might otherwise. I don't know, but that could be one consideration. I think the consequences, though, of doing it are not very wise for a couple of reasons. One is that, as Kristen pointed out, when you file in the D.C. court, it can take longer. Interveners can intervene in such a case, and that can, if the interveners object to preclearance, that could actually have some impact if there were no administrative proceeding that DOJ could simultaneously preclear. The the other is, it seems like when they file their complaint, they move to shorten the time for the department to answer the complaint. So what I think they're trying to do is an end run around the 60-day rule, because DOJ by law gets 60 days to review a map under the administrative proceeding. And of course, the DOJ gets 60 days to answer a complaint when you sue them in federal court. But if you move to shorten the time, you in essence can force the department's hand, I think, to agree that, well, okay, we will try to expedite. And sure enough, in both Louisiana and in Virginia, the Department of Justice opposed the motion to expedite, but agreed to an accelerated date by which they would administratively decide the pending Section 5 redistricting decision. So I think that's a sign of things to come. I do think in Texas, when the maps are finalized and the governor signs them and the Attorney General seeks preclearance, they will be in the DC court. I don't know if they'll be simultaneous or not, but I would be very surprised if they do not go to the DC court for preclearance. The other kind of, so there are a bunch of cases out there pending and percolating about prospective challenges, kind of wait and see cases to see if the legislature acts, and then if the legislature acts and the plaintiffs are unhappy with the map, they'll amend their complaint. The most interesting case, I think, right now for me, because I'm representing some of the defendants in the case, is a challenge in Florida. Florida passed 2 amendments to their constitution very briefly last fall. 62% of the voters approved amendments that restrict the legislature's ability to intentionally favor one political party over another when doing redistricting, and intentionally, they can't intentionally favor one incumbent over a non-incumbent or over another incumbent. So you have it's an intent standard, but it's really going to be interesting to see how Florida's legislature, which is dominated by Republicans and who have current districts that are gerrymandered to protect Republican incumbents for the most part, are going to be able to try to deal with these new amendments. And the lawsuit that has been filed and which is pending in the Southern District of Florida is a case brought by 2 of the incumbent members of Congress, Diaz-Balart and Corinne Brown, Republican and a Democrat, challenging the constitutionality of Florida Amendments 5 and 6 on the grounds that they impermissibly restrain the legislature's authority to draw congressional districts under Article 1, Section 4 of the Constitution. The Florida legislature has intervened as a plaintiff because they agree and they want to be able to keep the unbridled authority to gerrymander in their hands and allow some of their members maybe to move up the political food chain to Senate and congressional seats. So we'll see where that case ends up, and I think that's one of the more interesting ones. And the only other thing I'll say is that, in full disclosure on Virginia, I represented the Virginia Senate majority, and there we had 5 majority African-American districts under the old map, and we have 5 majority black voting age population districts under the new map. But the black legislators and a lot of the black community within those districts decided that the districts that had been drawn in 2001 had been packed much more heavily with African-American voters than necessary for African-American voters to elect their preferred candidates. And they wanted some of those black voters to be dispersed into adjoining districts where they could either have influence or, in some cases, an outright opportunity to elect because of minority population growth. So that decision by the Justice Department, whether to preclear, is coming out today. So we'll find out where that stands. But that's, I think, been another interesting approach.
Okay, so Marcia's prediction is true, isn't it? You're saying there are already 30 cases that have been filed in the lower courts since the beginning of the process. What about one-person, one-vote cases?
Well, this is an interesting new breed of case. Do you want to start, or should I?
Well, why don't we, Neil, let me give you a teaser, and then you can jump in where we are now.
Oh,
We thought we were done with one person, one vote after Larios. Before
some
Larios v.
background.
Cox.
Give them some background.
Okay, Larios v. Cox was a case in Georgia that followed up the Ashcroft case. It was a challenge by the Republican Party to the state legislative and congressional maps of the state of Georgia. They prevailed in the challenge to the state legislative maps, but not in the congressional maps. The nature of the challenge was that there was a partisan structure to the population deviations of the Senate and House maps. That if you were to look at the maps, all the Democratic districts were minus 4.99%, or 2/3 of them were. Most all of the Republican districts were plus 4.99% above average, and there was no other explanation for the population deviation, no rational or general public policy. So the three-judge panel in the Northern District threw out the maps contending that it was a violation of one person, one vote, because people who lived in a certain part of the state, mainly South Georgia and Central Atlanta, were more likely to be in an underpopulated district, and they used the same rationale they had used to throw out the county unit system back in the early 60s. In fact, one of the judges explicitly invoked this in dealing with Democratic lawyer Dave Hebert. So what happened is this overturned the notion that there was a safe harbor inside the 10-point range for state legislative redistricting plans. Any deviation, even inside the 10-point range, had to be justified by some general policy or some good government approach to redistricting. Well, we figured this pretty much took care of one person, one vote, because map drawers around the country are taking steps to minimize their population deviations or taking care that they don't have a partisan structure to them. But lo and behold, a new theory of the approach to one person, one vote has emerged, and Nina, I'm going to kick it to you.
All right. Well, and I'll back it up too, in case anybody's sitting there going, I'm not completely sure what's going on here. It's a really fundamental rule of redistricting, and it's why we redistrict after the census numbers come out. We are trying to equalize, or roughly equalize, population across election districts, because that's considered what's fair. This rule has been around for so long, nobody even thinks about it anymore. When you draw a redistricting plan, you're looking to equalize population across districts, and then you're looking at the Voting Rights Act compliance. If you happen to be a partisan attorney, you're looking at advantage for your political party. If you're drawing for an incumbent, you're looking to make a nice district for your incumbent. But always that rule is underneath, that the districts have to have roughly the same number of people in them. Well, there's this new breed of lawsuit, which I think, and Keith and I have to talk past each other on this one because we're both involved in one of the pending cases right now. Keith is an expert, and I'm representing defendant interveners. But there's a group of people who've brought a couple of cases that I think are really aimed at the burgeoning Latino electorate and burgeoning Latino population. Because there's sort of two ways to respond to burgeoning Latino population. One is to try to get the votes of Latinos by appealing to Latinos, or to ask for the votes of Latinos. The other way to do it is to try to figure out how to minimize the voting strength of Latinos, either through gerrymandering or this new theory of one person, one vote, which involves a little bit of math, but it's not threatening. And it just has to do with who gets counted for the purpose of equalizing population across districts. It's everybody. Right now, the standard is that the districts have to have the same number of total population. The case that we're dealing with that was filed in Texas, called LEPAC versus City of Irving, alleges that districts should be equalized in terms of population, but citizen voting age population. So children do not count towards the total population of the district, and non-citizens don't count towards the total population of the district. So Latinos who happen to have a younger age structure than other people, and who also may have more non-citizens living in and among in their neighborhoods, are going to be very disadvantaged by a system of counting people that doesn't include either children or non-citizens. So for example, you are sitting on two sides of the room, but you're sort of roughly equal groups. So you can imagine if we were redistricting, we would draw a district around you, and we would draw a district around you, and then you would be in two districts that were roughly equally apportioned. But if everybody over here who's wearing a necktie stands up, stand up, yes, yes, go, go, neckties, up. Okay, you're all either children, no, sit down, sit down.
There's always one, isn't it?
It's okay. I'm going to give you special credit. Imagine if you were all either children or non-citizens and you didn't count towards your district's population. Then there just wouldn't be enough people in your district, and we would have to put more people. It's okay to sit down now. We would have to put more people and more people and more people. So equalizing on the basis of citizen voting age population might have very little difference if you have two homogeneous communities next to each other. But if you happen to have a Latino community next to, let's say, an Anglo community in Texas, you might end up having to have a total population district that was half again or maybe twice the size of the neighboring district. It has a very significant effect on the quality of representation and on the ability to draw Latino opportunity districts. And so that's kind of the latest interesting type of lawsuit that we're seeing. It goes to one of the heart rules, one of the deep critical rules of redistricting. And the one that's been filed in Texas, I think, is definitely aiming for the U.S. Supreme Court. It's pending in the Fifth Circuit now. We won on summary judgment at the trial level. And then we'll see where it goes from the Fifth Circuit.
Keith, you want to add something?
Yes, and I can do this by mainly staying inside the filings of the attorneys in this case. The argument that's made for going to citizen-based apportionment is in part based upon a perception of a distortion of the relationship between seats and votes. That if you look at districts with large non-citizen populations, you elect winners with far fewer numbers of votes being cast. Political scientist Jim Campbell at SUNY Buffalo refers to this as a wasted vote or a cheap seat argument, that there are seats out there that Democrats win that have very low voter turnout. So, if we were to look at congressional districts in Texas, we discover the South Valley districts in a general election will have turnout that's less than half of that of a suburban district around Houston or Dallas. In order to get where they need to go, they have to go back and revisit the original one-person, one-vote cases from the 1960s and ask the court for a clarification, which is it a dilution of the individual right to vote, that the value of a voter's vote in translating it into representation is worth more or less based upon where they live in the state or in a jurisdiction, versus the notion of equal representation based upon a potential electorate or a group represented, the idea of equally apportioned, perfectly apportioned districts. This is where the conversation will be held as we move through the appellate process. There are electoral distortion consequences of the use of cheap seats. When Jim Campbell published this book 15 years ago, it was right after the 1994 Republican landslide, and I said, Jim, don't you think this is kind of piling on a bit? But it is a very real challenge. But when you talk to lay people in the public about the value of the vote, the idea of one person, one vote, you say, there's a district in the southern part of your state that elects someone based upon a third of the vote turnout, they feel like that's a gerrymander, even though it's a perfectly apportioned equal population district. Okay, Nina, I think I threaded that needle well enough. Thank you. Okay.
Kristen.
I just wanted to add one wrinkle to this discussion. So one person, one vote, standard governing rule for redistricting, with one exception. It does not apply to local and state level courts.
Mm-hmm.
So there are a number of states around the court that have these kind of small courts, elected judges, and these courts are terribly malapportioned. And this is one area of redistricting that LDF has been very focused on this redistricting cycle. The Supreme Court has essentially said that judges are different than elected officials, and so one person, one vote doesn't apply in this realm. But the Voting Rights Act does apply. And so we've had a few successful Section 2 challenges to malapportioned, unrepresentative courts in a number of places throughout the years. In Terrebonne Parish, Louisiana, this is one place that recently has gotten some attention within the state of Louisiana. It's a parish that's 20% black. They have 5 locally elected judges on their court, and they're all elected at large. And the black community there, despite their best efforts, because of the at-large system, has been unable to elect judges of their choice to the court there. So what does this mean in reality? You've got a local judge by the name of Judge Timothy Ellender, who in 2003 showed up at a Halloween party in an Afro wig, blackface, handcuffs, and a prison suit. The Louisiana Judiciary Commission decided to look into the complaints that were received about Judge Ellender's portrayal of African Americans, and found this, that his portrayal of African Americans in a stereotypical manner perpetuated the notion of blacks as criminals and inferior, and called into question his ability to be fair and impartial, particularly against the African American defendants that appeared before him. He sits on that court today. There was a bill that came before the Louisiana legislature that sadly was not passed, and so we are now looking very carefully to see whether the Voting Rights Act can provide some remedy to black voters in this area. But I thought I would just flag this as
Absolutely.
a particularly kind of unique exception to the one person, one vote rule
Right.
that raises some issues.
Right, again, as you say, it's important to flag that we're not just talking about congressional redistricting, we're certainly talking about local redistricting as well, with judicial elections as well as county commissioners, police jurors in Louisiana, and other city council, et cetera. So we know what the legal landscape looks like, right, on the lower courts as well as in the Supreme Court, and what we're facing as well as what the census numbers say. So let's go and move into the redistricting process. And we have a number of states who have adopted commissions, and then some who are still using the legislative process to redistrict. So Jerry, can you tell us about, commissions and districts? What are we looking at in regards to that area?
Well, since commissions exist in 13 states to draw legislative districts, and in some additional states they exist as a backup in the event that the legislature fails to draw a map, then there's a commission that steps in. And there are 6 states that have commissions that draw congressional districts. The 3 that often come to mind when people talk about congressional districts and commissions are New Jersey, Arizona, and California now. We don't know if California will, the redistricting commission there, their congressional map will end up in court, but I think it's a pretty fair assumption that it will. And Arizona's went through, their commission went through years of litigation when they implemented it. Their commission map was adopted in 2001, and they spent several years in court. And then New Jersey, their commission drew legislative districts earlier this year, and they got sued immediately under that map. So certainly, whether you have a commission or the legislature does it, all roads still lead to the same place, which is the courthouse. And it certainly doesn't guarantee, if you have a commission drawing a map, that you will draw a map that's less likely to end up in court, because the stakes are simply too high to not challenge a map, and the importance to representation is so critical that litigation is inevitable. The one thing I would say about the reforms and the commissions is there are a number of, there's kind of a mindset that if you have a commission drawing maps, that you're not going to have politics playing much of a role in the redistricting, that if you have citizens and good government types drawing the map, and you actually have criteria that says you can't look at election returns or partisan impact of your map while you draw the map, to me, and I think to a number of people who've written in this area, who've spent a lot more time thinking about it, that's really not the way to go, because oftentimes you have to take into account the political and electoral impact of how the districts are drawn, simply to ensure that the districts are in compliance with the Voting Rights Act, as well as to ensure that at the end of the day the map has some degree of partisan fairness to it, so that if a particular political party ends up, you can show that if they capture 70% of the vote, they're still going to end up with 45% of the seats. There's something wrong there, and so it's not necessarily the case that having a commission and have it with political blinders is really a very good best practices rule. I will say that with regard to California, again, here you have 14 citizens, and in a way, having people draw maps who really haven't drawn maps before strikes me as not necessarily having the best people draw the maps. I mean, it's a real art to drawing maps, and I think part of the reason that you see so many complaints coming out of a state like California, which is for the first time experimenting with this new process, I think that's why you see so many people up in arms about some of the maps that have come out.
Yeah.
I'll leave it there.
All right, so-
Keith may have more to say, or Nina, or others.
Go ahead, Keith.
Oh, where to start, where to go? Part of the challenge in this cycle when it comes to litigation is finding your hook. I mentioned the Larios case previously. That was a one-trick pony. once someone used population deviations to overturn a partisan gerrymander, no one was going to make that mistake again. So no one will make that mistake again. The problem that we're going to see is it's in part a fight over how to apply the Voting Rights Act relative to partisan gain. Democrats love minority votes, but they don't always like the consequences of the Voting Rights Act for where those votes are put or the types of districts they might have to draw, because it impedes the ability to draw some crossover or influenced or competitive districts. And this was part of the problem that we saw rising in Texas, as I recall, Nina, is this.
Oh, you know, both parties have really had
Yeah.
their day with
Oh,
Latinos.
Oh, I'm going there. You know, and then, you know, Republicans really love minority votes as long as they can make sure that they don't impact too many districts. This is just an empirical reality as well.
You're still threading the needle.
Yeah, I know. Well, the problem is that the litigation choices that are available are usually going to be, for the parties, are going to be based upon their partisan needs, which means that we may discover that there are going to be partisan inconsistencies in the application of the Voting Rights Act in terms of litigation strategy in the eyes of the parties from state to state. Map makers are well aware of this and are moving carefully to try and take care to not violate the law in the process, but they're not necessarily being as proactive as certain stakeholders, like those like Latino voters might desire. And I think the big fight this cycle is over Latino representation. This is the source of popular growth in the United States, in most of the major states. But in state after state after state, we're not seeing a lot of responsiveness in the crafting of opportunities for Latino representation. So I think that's where the most exciting litigation will be this time. Related to that, you have this issue of partisan gerrymandering, which everybody agrees is reprehensible and everybody agrees occurs. And political science, we now know how to measure it. We can develop you a multi-pronged test on how to test for a gerrymander and all of its attributes, but no one has a legal theory that will get a court to say, yeah, this is unconstitutional. So we kick it back to the attorneys to find us a mechanism for us to put our best science to work. So we look forward to hearing from you, because we're ready. I think that's all I've got.
Jerry, you talk
Well,
about partisan gerrymandering.
Yeah, on that last point, just let me say that, you know, the Supreme Court had 2 occasions in the last decade to come up with an articulable legal standard for measuring the constitutionality of partisan gerrymandering, first in the Vieth case out of Pennsylvania, and then there was a partisan gerrymandering claim in the Lulac v. Perry case. And in each case, we weren't able, as Keith points out, we weren't able to come up with 5 votes in the Supreme Court for what the standard should be. But you do have 4 justices who say that the issue shouldn't even be justiciable. Then you have 4 justices who say it should be justiciable, and they have various ways to test it. And then you have Justice Kennedy, who says, well, I'm not ready to say that it's not justiciable, but I'm not ready to justice it quite yet. And so he reminds me a little bit of people who get interviewed about whether or not Sasquatch exists. You know, they really want to believe it, that Sasquatch exists. And they've even seen some photos that kind of show him, but until they really touch him or see him for themselves, and so he isn't quite there yet. The more cynical part of me says that he will come up with a standard once Republicans bring a case up to the Supreme Court of partisan gerrymandering instead of Democrats, but we'll have to see if that ever happens. But you know, it's interesting because I expected this time around, and we may see this, but I expected this time around to see, because partisan gerrymandering cases haven't really had any traction in the federal courts, I thought we might see litigants using theories of partisan gerrymandering under state constitutional provisions and trying to go in under the state equal protection clause. And we still may see that, because I think that still is a unplowed ground that may prove fruitful for people who really have to masquerade their partisan gerrymandering claims as Voting Rights Act claims or OnePerson One Vote claims under Lawyersapos or whatever the theory happens to be, because the avenues for overturning maps are just so few otherwise.
Kristen, you look like you want to.
Nope.
Okay, great. So we've talked about, you know, congressional and some state legislative. What about on the local levels, Marcia? What are you seeing?
Well, you know, the statewide and the congressionals get all the attention, and that's where the focus is for a lot of politicians, where they put their resources, and where a lot of advocates focus. But I think increasingly we are all aware, or we realize that there is a need to pay particular attention to the local redistrictings. Your school boards, your city councils, your districts, any type of local district that has unequal population does need to redistrict. And these are the school boards, the city councils, the counties. These are jurisdictions that have a more immediate effect on the lives of citizens, and they sort of get away with redistricting without anyone paying attention. Even in states like Florida, where there's been the reform movement and amendments for 5 and 6, which focus on the statewide and congressional, and have been waiting for the preclearance to start moving there. The counties in Florida are already redistricting, and there are significant population changes in those counties that will have a major impact. So I just thought it's worth highlighting that while all the attention is up here, that there's a lot of activity on the local level that is worthy of attention.
Right, very, very important. And so we're talking about, you know, whether it's congressional or local level redistricting, what part would race play in the redistricting process? And, you know, what part should it play? I think I had an interview yesterday, and the woman asked me, when should race not play a part in the redistricting process? And she was calling from California. I'm just like, in California? When should race not play a part in the redistricting process? So, you know, I gave an interesting answer. Maybe you'll read it. Or maybe she wouldn't print. I don't know if she printed or not. But anyway, so I wanted to ask you all, what role should race play in the redistricting process?
Race matters. We, of course, live with the, shadow of Shaw versus Reno hovering over us, where the Supreme Court struck down a congressional district under North Carolina where it determined that race was a predominant factor in the redistricting process. And I think, the lesson has been learned and carried through since Shaw, that race cannot predominate in the way that we redraw district boundaries. At the same time, we have from the Supreme Court very clear guidance that compliance with Section 5 of the Voting Rights Act is a compelling state interest. So, I think race plays a role. It can't be the predominant factor. We haven't seen successful Shaw litigation in many years. I don't anticipate that we'll see any successful Shaw litigation going forward. Race does indeed play a role, and we have to be cognizant of race and the demographic changes and shifts that have happened over the course of the past decade, and we have to be thoughtful about ensuring that maps reflect the current makeup of communities. And in many places, this may mean creating new opportunities, new majority-minority districts that give new communities opportunities to elect candidates of their choice.
Nina?
Well, we're very much in the mode of trying to create additional opportunity districts to reflect the growing Latino population. And so the reason why I said both parties have their day, right, is that Latinos may not find a friendly map maker in either political party, because a lot of what's happening is being driven by incumbency protection. So the incumbents are like the nuns in the that movie about the beautiful woman singing, Julie Andrews singing, The Sound of Music. Okay? So what are the nuns saying? What are we going to do with Maria, right? Very emblematic. Because here there are many Latinos, right? And they're in districts now. And so incumbents are trying to figure out what to do with burgeoning Latino populations in their districts. Sometimes, not all the time, I know you're already getting tense. Sometimes, but not all the time, you may have a Democratic incumbent who is concerned about getting primaried by a Latino candidate inside the Democratic primary. And so sometimes we see less than perfect enthusiasm for creating a majority-minority district that a sitting Anglo incumbent may have to run in. So we get a little bit of that. Then we may also be facing an incumbent who doesn't think that he can win in the general. He may be making assumptions about his inability to reach out to Latinos, who I think are natural ticket splitters, at least in my very red state of Texas. We have a lot of very conservative Latinos, but we also have incumbents who don't think that they can get Latino votes. So they're trying to figure out how to make sure that there aren't so many Latinos that they lose in the general. So we are still very much relying on the Voting Rights Act and its structure of race-conscious remedies to deal with a lack of enthusiasm for drawing Latino districts from either party, because what it's really about is incumbency protection. Whether it's Illinois, where we were struggling against incumbents who didn't want too many Latinos in their district because of issues in the primary, or whether we're dealing in Texas with, as Keith pointed out, we have 2 congressional districts that have incumbents in them now who apparently do not believe they can get a majority of Latino votes. And so all kinds of things are being done all over Texas that shouldn't be getting done. We're seeing proposed plans for Congress that don't increase the Latino districts for congressional, even though we've shown a plan that can increase by 2. What we're seeing floating around right now are proposed plans that have no increase. In the Texas House, we're seeing a decrease of 1. In a Section 5 state, no less, we're seeing retrogressive House plan. We're not picking up the way our community would warrant it. And in California, where apparently the commission just hasn't heard about the Voting Rights Act, because that's really the only explanation I have, they're drawing fewer congressional districts that offer Latinos the opportunity to elect than what is in the current benchmark plan. They are drawing only the same number of assembly districts, even though we can do +5 and 5 more. And they are drawing 2 fewer Senate districts than what we have in the benchmark plan. They have elevated other criteria over compliance with the Voting Rights Act. So circling back to the question, what is race, what is its role in redistricting? We think of Section 2 of the Voting Rights Act and Section 5 as very vibrant, very real, really the tool that we need to use to navigate a scene that is dominated by partisans, to try to get Latino opportunity districts.
Are you seeing a post-racial element in the redistricting process and the,
No, I say racial elements. I mean, this is old school. We have folks who don't want to put us into majorities in districts for whatever reason. It doesn't really matter. I don't care if the guy who doesn't want to draw my map is a Democrat or Republican. He doesn't want to draw the map. So we go and we present our claims under the Voting Rights Act. We show the polarized voting. We show the historical circumstances. And often we fling ourselves onto the mercy of the courts because that's the only place where we can go.
So you talked about Texas being a Section 5 state and the other Section 5 states. So I guess we can talk about the DOJ effect and whether or not, what role DOJ is going to play, and and Marcia can talk about some recent submissions.
Well, overall, throughout this process, DOJ, if the jurisdictions choose to do the administrative review rather than go directly to the courts, we'll see about 2,700 submissions from the statewide and all the jurisdictions under DOJ. And so they have already started receiving the submissions, as Kristen mentioned, from Virginia, Louisiana, but there are a lot of county submissions that are making their way through DOJ, and as Jerry mentioned, they have the 60 days to decide. And the jurisdictions, as Jerry also mentioned, have decided to make a political calculus about influencing DOJ's hand by also going to the DC court. And that is, I think, in the past, as Kristen mentioned earlier also, it's quicker, it's less expensive to do administrative reviews. But in this era where Section 5 is continually under attack, that also becomes a tool in the redistricting process, and is jurisdictions are seeing how much they can move DOJ's hand in getting what they want by using the judicial review process. But one of the things that the Section 5 does that I don't think we've mentioned yet is the issue of burden. Because under the Section 5 process, the jurisdictions have the burden to show that the plan wasn't drawn for a discriminatory purpose or effect. and they cannot implement the plan until DOJ or the court has pre-cleared the plan. So the DOJ effect is and Section 5, are very powerful tools for the voices within the community who want to ensure that the plan drawers are protecting minority interests and minorities continue to have the ability to elect candidates of their choice, and that plans can go into effect until that process is thoroughly vetted and they make their case. And also, it allows communities to engage either in the comment process or, when needed, to intervene in the district courts and show, as Nina has been mentioning, there are alternatives that the plan drawers could have drawn and they didn't, and they have to make that justification of why not. And so this, the DOJ plays an incredibly important role, but now in the era of Section 5 under attack, we're going to be looking at how that influences the redistricting process and how DOJ pre-clears or addresses plans.
Well, what are you finding? Do you think that that communities that the Voting Rights Act was passed to protect can rely on the Department of Justice and the Attorney General to enforce the Voting Rights Act, particularly in instances like Nina's talking about, where there's a benchmark and that they're doing less than the benchmark?
Well, I mean, there it's clear if you have a benchmark and there's retrogression. I mean, you have a clear case there where DOJ should object. It's those instances where you want more than is the current benchmark. Is DOJ going to step up? And in Jerry mentioned in Virginia, where there are concerns about being able to create another district, a sixth district. What is DOJ going to do there? I mean, that is what we're all waiting to see.
Kristen's like, please.
Oh,
please.
no,
Go
I
ahead.
wasn't actually, but I will give, Louisiana always provides lots of colorful
Oh, yeah.
examples. So there's Louisiana's state legislative maps are now pending before the Justice Department, I believe and before the DC District Court. I believe their administrative determination is due Monday, so we'll be waiting to see what they do. But here's how the process played out. The state legislative map that they ultimately adopted preserves the same number of districts that were there before. So it doesn't appear to have a retrogressive effect. But Section 5 also requires that DOJ block those voting changes adopted with a discriminatory purpose. An alternative map surfaces during the hearings leading up to the adoption of MAP that in the Shreveport area address packing, severe packing. You've got one district in the Shreveport area that is 89% black, and I don't think any voting rights advocate would ever stand by the need to have a district packed at such a level to provide minority voters an opportunity to elect, ever. So an alternative map is proposed that addresses the packing in this area and creates a new district. It passes through committee, it's got bipartisan support. The state's own demographer says, yep, that district, this map produces four districts that would be effective for minority voters. The state presents its plan to DOJ and says, you know what, we don't think our map is retrogressive. We've used a 55% rule. All of our districts are at least 55%, majority minority districts are at least 55% black, and we think at that level they're all performing, right? So this alternative map is proposed, it's gaining momentum, and all of a sudden you have opposition from white voters in a small community right outside the city limits of Shreveport that said, no, we want to keep our community intact. We've got a different culture, a different heritage here. We don't want to be in a black district. More than 100 letters go to the legislature, strongly opposing this alternative map that has been produced. And as it turns out, as we dig, we find out one of the state legislators had his hands in activating the community and encouraging this opposition, which is clearly on its face discriminatory. And what happens at the end of the day? The alternative map dies, and we're back at square one, a map that has these packed districts in place. In our view at LDF, this is discriminatory purpose at its worst, and precisely the kind of discrimination that Section 5 was designed to prevent. And so we're going to be waiting anxiously to see what DOJ does with the map before it on Monday.
One more comment, but Gerald.
On this issue about Louisiana, and I think it illustrates in general a larger point about the Justice Department, and it's this, that if the Justice Department is concerned about the Supreme Court striking down the constitutionality of Section 5 of the Voting Rights Act, and they are, and they enforce Section 5 with one eye constantly on the Supreme Court about wondering whether or not, if they object to that kind of a map, is it going to lead to litigation in the D.C. District Court in front of a 3-judge court and a direct appeal to the Supreme Court? So if they become timid with regard to Section 5 enforcement because of that concern, we are going to have less examples of situations where Section 5 was actually used to block intentionally discriminatory maps. So you can't really be timid. We just made this point actually yesterday in a meeting. And so I think it's incumbent upon the department to certainly get all of the facts, but when it comes to a point that you have to object, what's the purpose of having Section 5 of the Voting Rights Act if you're so worried about its constitutionality that you're not going to enforce it? So I think hopefully we'll see the department acting strictly and factually based in the coming months. I've been asked very quickly to just touch on the issue of bailouts in light of Namudno. The Supreme Court refused to declare the Voting Rights Act, Section 5, unconstitutional. They did not declare it when they had the opportunity to do so. In an 8-1 decision, they said that the bailout provisions of the Voting Rights Act, which allow people to bail out from Section 5 preclearance if they can show a 10-year record of compliance with the Act and other requirements, that they can actually exempt themselves. Well, we're starting to see the bailout door open. The Department of Justice just filed something in the Shelby County constitutional case saying that in the last 30 days they've granted 3 more bailouts in the D.C. court, one out of California, one out of Texas, and one out of Virginia. There'll be about another 3 or 4 in the next month or 2, so there'll be a continuing effort to try, when the case goes to the Supreme Court again, to say, look, Section 5 may invade state sovereignty rights when it comes to making decisions about their elections, but if they don't like it, there's an ample opportunity to get out from under it. All you have to do is show that you're in full compliance with the Voting Rights Act for a decade and that you are affording truly effective equal opportunities. So I do think that we will see a number of efforts by the Justice Department to affirmatively get the good people out of Section 5 coverage and keep the people who really need to be covered.
My, how time flies. It's time for questions from you all. I think we must be on a different schedule than the other participants. We have one question here.
First question regarding WEPAC versus City of Irving, the voting age citizen eligible case. Wasn't there a case from the 1960 Supreme Court about military personnel in Hawaii and the argument
Yes, it's called Burns v. Richardson.
and how are the people involved in the City of Irving case treating that case? Because it seems to be a very similar situation.
We think that Burns was a very different situation because Burns dealt with people who didn't live in Hawaii. They were transient, they were tourists, they were military on bases. We consider Burns to be a very distinguishable case because the folks that we're talking about are constituents. They are permanently there.
Were they required to be counted?
They were not Hawaii, but the court observed that it didn't make a difference either way. The result would have been the same.
Other questions?
If I can ask you to go back to the discussion of counting prisoners that you spoke about an hour ago, is there any constitutional or other legal argument supporting counting prison inmates at their home addresses as opposed to in the location where the prison is?
Well, that's under the state laws, that's what the states have the right to have the prisoners counted at their home address.
I understand the state.
Right.
My question is there any
That's not something I've looked into, but I don't know if
He
anyone
asked if
else
there's,
has
you asked if there's any,
can the state compel the state to count them at home rather than where the prisons are? Is there a constitutional basis? I have to look into that.
Yeah, as we've said, most states, deem prisoners legal residents of the place that they came from. They're not legal residents at the places where they're detained on census day. And certainly the Voting Rights Act would seem to have some implications in those communities where there is stark racial impact. And we'll see how these issues unfold in the Little versus Lat 4 litigation that's now pending in New York. And I think it's contemplated that the Voting Rights Act may be used to address the problems in those states that fail to adopt some corrective remedy this cycle, and where there's stark racial impact.
I think we have time for one more question. We did start a little late, so.
And there is a lawsuit pending in Texas right now challenging prison-based gerrymandering in the federal court in San Antonio.
Hi. With respect to citizenship, voting age, population, and I mean, it seems like the data is pretty questionable at best in terms of the available data. That's if we're having to rely on that, and I know with some of the circuits that are requiring citizenship to be considered in the count. So, if say on Section 2, if the burden's on the plaintiffs to prove that, and there's no valid way to prove that, that seems problematic.
Our position is that that the data is valid and it's usable, and we're using it to prove up our Section 2 cases. There may be some people out there who question the validity of the data, but we don't.
Okay. Thank you. That will end our panel today. Thank you so much for coming. Hope you enjoyed it.